far as we know, you're flying solo. There's been no appearance and no briefing by the appellate.
Yes, sir, that's correct. That's my understanding. Your honors are probably aware I've been sending all the correspondence and pleadings to Ms. Carnes, and I think initially the initial brief went to, and perhaps things thereafter, to the respondent mother, but I've never heard anything. And
Well, you asked for oral argument, so this is your opportunity to present your client's case.
Thank you, Your Honor. May it please the court. Your Honor said something that stood out to me just a minute ago. It said, everyone gets their due process. As you've seen in our brief, although this case didn't begin with it, the case really began with Mr. Bradley's petition to determine paternity and for other relief that was initiated with his August 7, 2011 filing, and thereafter, after the mother finally admitted paternity, he filed an amended petition in January 2012. Preceding that, there were some domestic issues going on between the parties. Mr. Bradley had called the police a few times. He had to go to the hospital because of the mother. I'm referring to the mother as the respondent, of course, and I'll refer to him as Dad if that's acceptable, or if Your Honors would prefer petitioner respondent.
Whatever's convenient.
Okay, all right, sir.
For you.
Thank you, sir. And eventually the mother had taken out an injunction that was issued by the trial judge in this case, Judge Todd, in April 2011. And thereafter there were issues of the youngest child was taken to the hospital while in the sole custody and care of the mother with severe facial injuries. There was a shelter hearing 2 days later. The kids were taken from the mother. The father was not notified of the injuries to his children. There was the injunction that was issued against him in April 2011 was a year-long injunction that parties were supposed to go to CASA to complete paperwork so that they could exchange the children at CASA. He went down immediately, filled out the paperwork, couldn't get the mother to go. She never went. He never saw his kids. And then next thing, he doesn't find out about this for quite a while later, when the youngest child was taken to the hospital with the severe facial injuries in May 2012. The hospital called DCF. Shelter hearing 2 days later, the kids were taken from the mother. Mr. Bradley wasn't notified of the shelter hearing. There's no indication that he was ever even attempted to be served for the shelter hearing. The mother maintained that she didn't know where he was, although she used to live with him at his parents' house where he resided. And in June 2012, the mother went back in front of Judge Pierce, entered a consent plea to undergo a plan, and eventually she filed, and the father wasn't notified of that, wasn't there at that hearing. There was a plan issued by the court with which the mother had to comply. She hadn't fully complied, but in October 2012 filed a motion for intact family move. And I think a couple of these items were filed as part of the record. We could supplement the record because we do have these, the motion for intact family move, which simply says the mother was reunited with the children on September 2012, and the mother wishes to relocate the family to the state of Illinois, the 3 children, due to financial and family support. Those are the only things set forth in the motion for intact family move, woefully short of what the statute requires. The father was eventually found out about that and was able to attend that. That was the first hearing that he was able to attend or was notified of, and actually attended and had a voice at which he had a voice. In December 2012, a few months later, that was when the hearing took place on the October 2012 motion. The court entered an order granting that motion for intact family move on December 7th. We do have that order as well as an order on Mr. Bradley's visitation rights that was entered on December 12, and then an amended order is issued a month later without a hearing, without notice, without anything, unilaterally evidently, or for whatever reason by Judge Pierce, modifying his December 12, 2012 order on Mr. Bradley's visitation rights. And in that January 14, 2013 order, he further limited Mr. Bradley's visitation and co-parenting time-sharing rights.
Can I ask you a question?
Yes,
Because
ma'am.
in looking at this, and these type of cases, as you know, they're very difficult for any judge to handle.
Yes, ma'am.
Because sometimes it's difficult. You have two people in totally opposite positions, and I think one of the terms that the judge used here, it's a very toxic relationship.
Sure.
Regrettably, this is what's going on. But going through the whole history of this case, when ultimately your client got notice of a hearing, and then he attended, and then it came out adverse to his position, there's really he didn't file a notice of appeal, he didn't challenge that. And what we have before us at this time, as I see here, you have now Judge Todd, who basically did a detailed final judgment explaining her reasons. And as you know, the issues of credibility, we have to defer to Judge Todd. We cannot, the three of us, say, oh, Judge Todd, you got it wrong. We like the father. We want the father to have it. We can't do that. We just have to look and to see, is there error in that judgment that is appealed. And if you look at that judgment that she prepared, she basically has language in there that she kind of doesn't think that credibility on behalf of your client was questionable for her. And so how do we get around that?
Well, I think that there are a couple of bases for the appeal. Aside from the purported interlocutory orders, it is a bit of a, it's not a clear issue on the appealability of these underlying orders. Mr. Bradley's petition to determine paternity and for related relief predated all of these motions, and they were sort of consolidated to a degree in this dependency court shelter, but at the same time they had different case numbers. And if these matters were heard with the other case number under which he had filed the case originally, they would be interlocutory orders, I believe, in that family law proceeding on, for instance, a motion for intact family move, et cetera. But because they're a different case number, and so I think the appealability, I think Mr. Bradley's thinking at that time was, I've still got my petition for custody of the children pending, and ultimately I'm hoping that I can undo all of this stuff, most of which was done before he was even able to get involved. But with regard to your question as to how we undo Judge Todd's order, among our bases for appeal there were a number of issues of evidence that was refused. There were a lot of witnesses that were proffered by Mr. Bradley that goes to a couple of the considerations, credibility being one, the care of the children, the best interest of the children, the health and safety and welfare of the children, overriding all other concerns really, were what all of these persons who were proffered to testify were denied by the court as being res judicata. I don't see that it's res judicata if there's evidence of abuse or neglect of children at any time while in the care or custody of either party. I think that that's always a consideration for the court in determining with whom the children should be permanently placed or primarily placed back then. And I think that although she made detailed findings, I believe that the findings that she made were contrary to the evidence, and I believe that she erred in refusing to allow evidence of the abuse and neglect that had preceded the final judgment, the trial of this case, as well as there were numerous credibility issues within all of that, within the witnesses' proffered testimony that were going to contradict what the mother had to say about this, that, and the other thing pertaining to the children.
Could I ask you
Yes, sir.
a jurisdictional question? Your client, pro se, filed a motion for rehearing after the order on appeal was entered, and it was struck as authorized because the trial court believed there was still counsel involved. So is the notice of appeal timely if the pro se motion for rehearing did not stop the clock?
The motion for rehearing filed on the underlying judgment.
Yes, sir.
I don't know the answer to that question. It seems to me, I guess obviously an argument could be made either way. My understanding, and I don't recall the timing of it, Your Honor, I apologize. And I'm assuming then that the notice was filed more than 30 days after the judgment? That's what
I'm seeing.
Otherwise, I'm assuming Your Honor wouldn't be asking the question, so I don't have the dates of filing.
My understanding is the final judgment was entered in early November of 2016.
November 3, I believe. Yes, sir.
Your
November 3rd.
client filed a pro se motion for rehearing on November 18. And then the trial court struck that motion on December 7. And the pro se notice of appeal was filed on December 15.
Okay, my feeling on that is, number one, I think once a final judgment is entered, counsel is no longer of record. I don't know that to be the case. At that point, I don't believe I had filed a notice of appearance or filed anything on behalf of the petitioner. I understand, Your Honor, most of the rehearing is still down in the trial court. Right. But if you filed a motion for rehearing and there is a motion for rehearing filed, irrespectively of whether I filed it or my clients filed it, but the court then waits the 30 days beyond the appeal date to enter the order striking the motion for rehearing, when there's a good faith reliance on the implication of a motion for rehearing, irrespectively of who's filed it, I think that's quite a bit unfair to the petitioner, Mr. Bradley, to have allowed the time to lapse and say, no, I'm not going to hear or give any credibility or credence to your motion for rehearing. I'm going to strike it, but now you're too late to file an appeal. I don't think that if you're going to err on either side, I certainly think you should err on the side of the rights of the party to take an appeal when he's made a good faith when he's filed a good faith motion for rehearing in a timely manner, 15 days after the judgment. I don't know if there's a case that says if it's subsequently stricken, but I certainly have. I can't imagine that the law would allow it to be stricken after the deadline to appeal when he's relying in good faith on the.
I understand.
Okay,
I understand what you're saying. Thank you.
Yes, sir. Thank you. When we look at the actual evidence, Your Honor had asked about substantively, Judge Todd did make detailed findings, but there was, because so much evidence was disallowed, there was evidence of the abuse, there was evidence at trial of the children's failure to thrive while in the custody and care of the mother at the 1 percentile range, and then 2 weeks later, Mr. Bradley gets the kids up to 25th and 13th percentile. There's a recommendation of medical procedure for his son to allow his son to breathe better, and this is entered, the medical note, I think it was 2017, recommending this surgery. Mr. Bradley's been trying to get him to have this surgery done. Here we are in 2019, this young boy is still suffering because there's been no medical attention. There's an 8.5 and a 5.5-year-old kid wearing pull-ups. There's behavioral issues. There's violence among the kids. They're acting out. There's refusal to cooperate by the mother because it's just too much for her to deal, quote, deal with Mr. Bradley. So consequently, she doesn't put him as an emergency contact. She doesn't put him as a dad. She tells everybody she was a victim of abuse. He can't get in touch with, he doesn't know whether they're going to school. The court had ordered her to let him know where the kids are going to school, where they live. Never gave him that information, still doesn't give him that information. She doesn't communicate, she doesn't cooperate, she admits that. And that's one of the key, it's hard enough to co-parent when the children are up in Illinois and he's trying to talk to them on the phone. They're all in the room together in the background. The court had ordered them to be separately in the room. She doesn't do it. She doesn't do anything that she's supposed to do, and all at the expense of the children and their relationship with their father. And the evidence is really substantial in this regard. Obviously, it's all in the brief. When they moved up there for financial reasons, she said she had a job lined up, and then she comes back at the next hearing and says, I can't afford daycare because I can't get work. It's just one lie after the other. It's to frustrate Mr. Bradley's right to have an active role in his children's life. The testimony was that he is very involved with his children. He is engaged with his children. He spends time, quality time. He spends time with them going over their homework and discipline and cooking for them and trying to raise them in the right way. In the meantime, they move up and they're living in a house, a 3-bedroom home with 13 people, and then another home with 8 people, and bouncing around to different addresses of which Mr. Bradley's not notified, and in environments in which they're not happy and they're afraid of their paramour. They've all three admitted or stated to medical providers. I'm not real sure, quite honestly, of the I guess, interlocutory nature of these other orders in which he was afforded no due process. There was no due process. The motion for intact family move had absolutely no compliance with the statute, and notwithstanding all of that, was granted. And I know here we sit, 6-7 years later, trying to undo all this mess, but what it did was it made Mr. Bradley's burden essentially insurmountable to come back after a move is granted, and he's burdened with an even higher burden to get his children, when initially he was just trying to get custody, primary custody at least, of the children, and it ended up being what amounted to having to prove a substantial change of circumstances because of the underlying orders that were issued in the dependency/shelter case. And on the one hand, he's bound by those and now has to meet this substantial change of circumstances to overcome them. And on the other hand, there's an argument, well, those should have been appealed way back then. Well, they're either one or the other. If they're either part of all this, which they would normally have been in a family law proceeding. These things happen along the way. When people do get job opportunities and do want to move, they file their motion, their petition for intact family move, and there's a hearing and both parties are heard. But that's not what happened here. And this is not a case where he's trying to get back at the mother or anything like that. He just wants to have an active role in his life and in the children's life and lives, and wants the children to be healthy and safe and grow up in a loving environment. And they're not getting any of that, and they never have. And the evidence is clear that they never have. Now, the final judgment can say what it says about what the evidence showed, but the evidence shows overwhelmingly all of these things. And it's a very sad thing to see that these children are continuing to have ongoing behavioral issues, have fear of the environment in which they're living. They're not thriving. In fact, doctors are saying they're failing to thrive. And we believe that the court's order or ruling disallowing the evidence for Mr. Bradley, and yet, for instance, with the paramour of whom the children are saying they're afraid, Todd, or his last name is, allowed the Skype testimony of him in violation of the rule. There was no notary there when he was testifying at trial. There was no prior notice that he was going to testify as far as stipulation. There was no other good cause to allow it, but even if good cause were allowed, he's supposed to have a notary there and he's supposed to be sworn in and testify. But that was allowed. And yet, the police and the DCF and all of the people that were part of and were intimately familiar with the mother's treatment and neglect of the children were disallowed. And that's, to me, that is the most important thing, because without health and life, there's no need to, there's nothing about which to communicate and correspond and do all these things. But the parties have to keep each other advised, they have to be able to communicate, and she's admitted she just, with the crocodile tears that I've mentioned, saying she can't communicate and correspond with him as a basis for failing to keeping Mr. Bradley advised and informed of what's going on in his children's lives. In fact, he just found out through one of his other children that his son...
we don't want to hear things that are not in the record, sir.
I apologize, Your Honor.
You're going to have to wrap it up, please.
Yes, sir. So we believe that the court's rulings with respect to the refusal to allow evidence of the witnesses that were proffered was an abuse of discretion, and that the evidence supports a reversal of the trial court's final judgment of paternity.
Thank you very much.
Thank you all for your consideration. Have a good day.